What is test identification period? Test identification period is defined under Section 9 of Indian Evidence Act. Section 9 reads as facts necessary to explain or introduce relevant facts. Facts necessary to explain or introduce a fact in issue or relevant fact are which support or rebut an inference suggested by a fact in issue or relevant fact or which establish the identity of anything or person whose identity is relevant or fix the time or place at which any fact in issue or relevant fact happened or which show the relation of parties by whom any such fact was transacted or relevant insofar as they are necessary for that purpose. Illustrations. The question is whether a given document is the will of A, the state of A's property, and of his family at the date of the alleged will may be relevant facts. B. A's use B for a libel imputing disgraceful conduct to A. B affirms that the matter alleged to be libelous is true. The position and relations of the parties at the time when the libel was published may be relevant facts as introductory to the facts in issue. The particulars of a dispute between A and B about a matter unconnected with the alleged libel are irrelevant, though the fact that there was a dispute may be relevant if it affected the relations between A and B. Next illustration. A is accused of a crime. The fact that soon after the commission of the crime, A absconded from his house is relevant under Section 8 as conduct subsequent to and affected by facts in issue. The fact that at the time when he left home, he had sudden and urgent business at the place to which he went is relevant as tending to explain the fact that he left home suddenly. The details of the business on which he left are not relevant, except in so far as they are necessary to show that the business was sudden and urgent. Next example. A sues B for inducing C to break a contract of service made by him with A. AC. On leaving A's service, says to A, I'm leaving you because B has made me a better offer. This statement is a relevant fact as explanatory of C's conduct, which is relevant as a fact in issue. Next example. A, accused of theft, is seen to give the stolen property to B, who is seen to give it to A's wife. B says, as he delivers it, A says, you are to hide this. B's statement is relevant as explanatory of a fact which is part of the transaction. Next example. A is tried for a riot and is proved to have marched at the head of a mob. The cries of the mob are relevant as explanatory of the nature of the transaction. Identification of accused. If the test identification parade regarding accused was not conducted properly and suffered from unexplained delay, he is entitled to benefit of doubt. It was held in Rajesh Govind Jagesha versus State of Maharashtra, AIR 2000 SC 160. Next, the possibility of wrong identification due to loss of memory cannot be discounted. held in Prabhakar Behera versus State of Orissa, 1997, 2 crimes 108 Orissa. Third, when conviction was based on evidence of eyewitness and not on identification period, it cannot be set aside on ground that identification was not reliable. Mullagiri Vajiram versus State of Andhra Pradesh, AR 1993, SC 1243. Fourth, in dacoity case where all witnesses identified suspects as culprits without margin of error, creating doubt in mind of court, such identification is liable to be set aside. Held in Tahir Muhammad Kamad Girendra Singh and Badri Singh versus State of Madhya Pradesh, AIR 1993, SC 931. Next example, where both the trial court and the appellate court had assessed the evidence in the proper perspective and attached much importance to the evidence in regard to the identification of the appellant in finding him guilty. The Supreme Court would not reassess that evidence in absence of an exceptional ground necessitating such reassessment. Ramjiyo Rai Yadav versus State of Bihar, 1990, Criminal Law Journal 1183 SC. Next example, if there is unexplained and unreasonable delay in putting up the accused persons for a test identification, the delay by itself distracts from the credibility of the test. Rajnath versus State of Uttar Pradesh, 1998, Criminal Law Journal 422. Another example, the test identification parade conducted 3.5 months after the dacoity took place. It would be wrong to convict the accused on single testimony. Vakil Singh versus State of Bihar, 1981, BLJ 462.